Hello, this is Paul Callaghan, and Happy New Year to everybody who's joining us for our webinar. So as you can see from the agenda, we've got a lot to cover today. So inevitably, we'll only be going into very brief detail on many of the topics. Needless to say, as well as being able to ask questions during this webinar, do feel free to send us an email after the event if you'd like any more detail on any of these topics. Today, we're hoping to cover the key legal issues that if you're doing business in the UK or the rest of Europe, you need to be aware of in 2016. And one of the most important issues, if not the most important issue for 2016, is data privacy. So without further ado, I'm going to hand over to my partner, Bange, who heads up the Taylor Wessing's data privacy practice.
Thank you, Paul. The first topic I wanted to cover today is just to look back at the issue of US safe harbor and data exports. The background to the whole US safe harbor issue and the Schrems decision is probably not news to anyone anymore, and we have explored this issue in quite a lot of detail in a previous webinar back in November, when alongside our International Data Protection team, we also had Christopher Graham, the UK Information Commissioner himself, speaking at our webinar and presenting his views. So if you want to listen to this topic in much more detail, that webinar is still available on the Taylor Wessing Global Data Hub. But in terms of the safe harbor decision, well, it has happened, and it's still a shock for many organizations we speak to, but it has happened. That safe harbor is no more. And given the impact that this has on so many North American businesses that collect data from EU citizens or have affiliates that are based in Europe, and therefore those affiliates will leverage the US systems and infrastructure to process the data that's captured from within the EU businesses. It's quite clear that this sort of issue, and particularly the absence of safe harbor, which is used to provide that coverage and to legitimize and validate those data exports, with that disappearing, it is clearly an issue. But the question still arises that now it's happened, what do organizations do and what should they be doing? I think the first thing to just think about for a moment is there any sign of Safe Harbor Mark II or version 2? There are a lot of rumors circulating that Safe Harbor may be about to emerge in its new shiny form. However, as far as we can see, these are clearly nothing more than rumors. There is no clear sign that we have seen that points to an emergence of Safe Harbor 2 in anything like the short term, or certainly anywhere near the end of the January grace period, the 31st of January grace period that has been granted by the data protection authorities across Europe. The point to note, and we've covered this in a lot more detail before, but I think it's just worth emphasizing, is Safe Harbor was never the only solution to legitimizing data exports. There are a range of other solutions that are available. For those organizations that are perhaps much more advanced in their compliance and accountability programs and their governance around data exports, they may be close to or maybe considering or may even have BCRs in place, binding corporate rules. And that might be on a controller-to-controller basis, in other words, that intra-group scenario, or perhaps on the more recent developments in terms of BCR for processors, allowing for data exports, in particular of client data as part of a global organization. So BCRs are clearly still a valid route available to overcome the data export issue and the gap that Safe Harbor has left. There are practical limitations as to whether or not BCRs are a viable solution for organizations looking to plug that gap, and the practical solution is really one of time. BCRs are not a solution that you can put into place overnight. They take time to plan for, to implement, to roll together and put into an application, even before the time that's required by regulators to actually go through your application and approve it. So whilst they remain an option, in practical terms, they're certainly not a short-term option at all. You'd be looking at BCRs as a perhaps medium to long-term solution to plug the gap that safe harbour has left for you. Model clauses with use of the European approved standard contractual clauses, either the controller to controller or the controller to processor, are really the most viable option that's left for many organisations. And again, we explored the use of model clauses in much more detail in our November webinar. So if that specific area is of interest, and I would really encourage you to listen back to that webinar. There we explored the differences between controller to controller clauses, the controller to processor, and also the sub-processor elements around data export. And we also looked at how important it is to look to model clauses not only simply between the exporter and importer entity, but also what that really means for your organization in terms of how you need to plug the gap left by safe harbor in terms of model clauses in your clients and customer arrangements, but also how you flow that down into your own infrastructure providers as well. So there is that entire sort of linear approach that you need to take towards model clauses and how you provide for that adequacy to flow and follow the data. There are, of course, other derogations such as consent, but again, as has been explored, certainly in these webinar series before, where we looked at consent, for example, in the employment context, again, it has its limitations because the European regulators have cast a shadow over consent and whether or not it really works as a viable alternative to the other solutions that we've mentioned, primarily because it doesn't always tick the box as far as consent is required to be explicit, where the explicit nature of it is required, but also whether or not it's actually freely given. So, many organizations now, if you haven't already, ought to be looking at your supply chain, looking at those suppliers that are providing you with services and therefore processing your data, which may include European data protected data, to ensure that you have model clauses in place, or those providers have another solution such as binding corporate rules in place to do that. The next point I wanted to explore today was that of what 2016 is going to bring to us in terms of European data protection law. And by far, the biggest development is the General Data Protection Regulation, the GDPR. And we all knew that just before Christmas, the negotiation process, which had been going on for some mere 4 years, was finally concluded. And the European Parliament and Council are expected to formally adopt the agreed text possibly next month, but we think it's more likely to be early March. After that, and once it's finally adopted, it will be officially published in the European Journal, and then will come into force 2 years later. So organizations will have that 2-year period of implementation with that sort of long stop implementation date of probably somewhere between March and May 2018. Now, the text has not been formally published in its final version. The somewhat untidy version that was released and published before Christmas, it is just that. It's just the agreed text, but it's not the final polished version that will be released in probably 2 months' time. In terms of just picking out some of the headline points that will be of relevance, particularly to North American businesses, especially when compared to the current regime of data protection, territorial scope is something that's very new. And although we've seen territorial scope examined in recent times, particularly in relation to Google Spain, the Gonzalez case, territorial scope is something that is addressed within the GDPR, and we will see an expansion of the territorial scope of EU data privacy law as it becomes applicable to non-EU organizations that are offering goods and services to data subjects that are in the EU, or if they are monitoring their behavior to the extent that that behavior takes place in the EU. So the long arm of data privacy is finally going to see itself enshrined into European privacy law. Many organizations that are North American driven with affiliates across Europe would probably be familiar with the pain of notifications that need to be either filed, lodged or declared across different countries in Europe, with each country having its own approach towards notification. So the requirement to notify authorities of data processing will be removed. So I think that's quite a welcome change. But coming in will be a requirement to keep records of data processing activity. So on one hand, you've seen the declaration and notification requirements being removed, but the accountability and compliance aspects of the regulation are putting that obligation onto organizations to make sure they have their own records in that regard. With the one-stop shop is also a very welcome development here. Instead of the current approach, which is 28 different data protection laws, 28 different regulators, organizations will be regulated by one single regulator, and that will be in the place of their main establishment. This is a really key change, and I guess a welcome change as well, simplifying and somewhat streamlining the approach that you need to take in terms of which regulator do you actually base your European operations towards. Penalties are a big development as well, and the word big is perhaps the operative word here. Currently the fines range in the region of up to hundreds of thousands of pounds, in the UK up to £500,000 for the most serious offences. The regulation introduces a penalty regime with maximum penalties of up to 4% of global annual revenue. Now that's a sea change, and that will have a huge impact on governance, risk decisions, and other aspects of data privacy compliance that are being introduced by the regulation, such as accountability, a greater and enhanced requirements around consent, and accountability through tools of compliance which are not necessarily mandatory legal requirements right now, maybe best practice, such as data protection impact assessments and privacy by design, but these will become mandatory requirements, and also failure to adhere to these governance requirements and have such tools in place may also attract fines at those most serious levels. And clearly there's quite a lot of points of impact as a result of the General Data Protection Regulation. And this is something we're going to explore in much more detail next week when the International Data Protection team at Taylor Wessing will be hosting a webinar very specifically on the topics of data privacy and 2016 development. So if you want to hear more about the impact of the General Data Protection Regulation, please do tune into that. That'll be next week, and the details can be found on taylorwessing.com, and in particular the Global Data Hub, alongside the references I've made to the previous webinars covering Safe Harbor. So for now, I'll hand back to Paul.
Hello, and as some of you may know, I head up the Taylor Wessing's employment law practice. And I'm pleased to say that as things currently stand, we hope there won't be too many changes in UK employment law that are going to affect you in 2016, unlike before data protection. As you may know, if you do business in a large number of European countries, even though the UK's employment laws can initially seem onerous because we don't have at-will employment, they are in fact the most flexible across the whole of Europe, and in very many ways the UK is the best place to start your expansion into Europe. Nothing in that respect is going to change in 2016, and my colleague James is going to talk a little bit later about some changes in Germany and in the Netherlands where you expect there to be more regulation, and indeed there is. But some changes that are coming into force in 2016, if you're a large company with 250 or more employees in the UK, then during this year you are going to have to do a report in relation to your gender pay gap. That's obviously potentially quite burdensome, and in that you are going to have to collate and publish data showing the difference between what you pay your male and your female employees. But as I say, that only applies if you have 250 employees or more in the UK, and do get in touch if that applies to you, and we can give you more detail. Those of you who are used to potentially paying tax-free severance amounts to employees when they're terminated in the UK, that's all up for review. It looks like there are going to be some changes. The £30,000 tax-free payment, which has been in place certainly throughout my entire career, looks like it may be about to go, or at least be seriously amended. So watch out for that, and don't assume if you're terminating employees in the UK that rule will still apply. The Modern Slavery Act is something that you do need to be aware of if you have a global turnover of £36 million or more, so about 50 million US dollars. It doesn't matter how small you are in the UK, but if you do any business in the UK at all, so that will include any US or Canadian parent companies, and your global turnover hits that threshold, then you are going to have to put a Modern Slavery Act statement on your website. The date that you have to do that varies depending upon the end of your financial year. But essentially, the first companies are going to have to have done that within about 6 months at the end of March this year. So in other words, by about September. And failure to do that, as well as potentially being bad PR, could theoretically result in an injunction and fine. So if that applies to you, again, do get in touch. And if you're used to responding, if you do business in California and you already have a statement in relation to the similar Californian Act, then there are only a few amendments that need to be made to that, and that's something we can also help you with. Now, working time is a big issue in the EU generally, and slightly less so in the UK than the rest of the EU, but we do have recent case law that's made it clear that travel time is working time. Now, that is relevant in terms of the minimum wage, and it's also relevant in terms of the maximum working week, which some of you may know is 48 hours, averaged over a 17-week period in the UK, which is the highest that is actually allowed in Europe. We've just recently had a change in relation to 0 hours contracts. Now, a 0 hours contract is where where there's no guarantee of work. But if you have a 0 hours contract which prohibits an employee, a person from contracting with some other company, so it's basically requiring exclusivity, that's been banned now. And if anybody lost their contract with you because you objected to them contracting with someone else, that will be an automatically unfair dismissal. And from day one, basically. So the normal 2-year service requirement you have for unfair dismissals in the UK won't apply for those on 0 hours contracts if they lose their role because of any exclusivity requirements. So watch out again if you're a business that uses 0 hours contracts. Another issue to be aware of, holiday pay. The big issue of last year, when employees who regularly get paid overtime had to have their vacation pay take that into account, potentially very costly. Well, it also applies in relation to employees who receive commission, and that, I imagine, will potentially affect a lot of people listening. Now, it's not something that many employees have challenged so far, but you do need to be aware that the courts have now ruled that if an employee does receive commission as part of their pay, that ordinarily you are going to have to account for commission when you're deciding what they get paid when they're on vacation. So it's not just basic salary. Now, the courts are still in the process of telling us how we calculate that, so it's not clear. But that is a potential cost for a number of businesses. And again, if you'd like more information, do get in touch. The final issue I wanted to mention is employment tribunal fees. You may know that fees were introduced to bring employment tribunal claims about 2 years ago, and the number of claims as a result of that dropped dramatically. There have been a number of challenges to the fees that were brought in, and there is a further challenge that is expected to be heard sometime in 2016. So there is a risk that fees will go or will be significantly reduced, and there will be more employment claims. Again, just keep in touch and do let us know if you are looking to terminate anyone who may have unfair dismissal rights. And as I mentioned earlier, that's generally employees of 2 years service or more, and then we can help you deal with that in as cost-efficient way as possible. And although there shouldn't be too much on the UK employment law side, there are going to be some big changes in relation to immigration law So I'm going to hand over now to Charlie Pring, who can tell you more about that.
Thank you, Paul. I'm Charlie Pring, Senior Counsel in Taylor Wessing's immigration team. I just wanted to take a couple of minutes to give you a very high-level review of the changes on the horizon to the UK's immigration system and how they're going to affect UK employers, particularly looking to hire non-European talent. So I think the first thing to understand when you're looking at the immigration system is the political context, the background to the work system. And you start with 2010, when David Cameron became Prime Minister. He made a very high-profile pledge to cut net migration. That's the number of people coming into the UK, less the number of people emigrating out of the UK, to below 100,000 per year. Actually, what's happened over the last few years is that it has risen steadily and is now standing at 336,000, so more than three times the level that the government wants it to be. A lot of that spike in the numbers has been caused by European migration, so European citizens coming from especially the Eurozone countries to the UK, which has very strong employment levels, but also a rise in non-European migration as well. Now, because of European free movement rules, the government can't control European migration, so they're looking at the slice of the pie they can control, which is non-European migration. So people coming from outside of Europe to the UK for work purposes. And one of the headline changes that we expect in the next few months is a change to the Tier 2 visa route. The Tier 2 system, as many of you will know, is the work permit system for the UK. So it requires a UK employer to sponsor a non-European to do a skilled job at a certain minimum salary. And from various policy decisions made in the last few years, the government has funneled employers into Tier 2. It's closed down some of the personal visa routes, so it wants to push everybody into Tier 2 so it can control skill level and salary level. And there's about 30,000 employers in the UK that have Tier 2 sponsorships, so it's a very common system. But what the government perceives to be the case is that employers are overly reliant on Tier 2 visas. And on the back of that, they've asked the Migration Advisory Committee, that's an independent committee that advises the government on immigration policy, to come up with some recommendations to reduce the visa numbers, to make it more difficult for employers to recruit using Tier 2 and therefore try and reverse that trend of a net migration level. We are expecting a report probably within the next couple of weeks to be published. It's gone to government, but it hasn't been made public yet, with some recommendations on how to restrict the system. We expect there to be some changes to intra-company transfers, perhaps particularly to the technology sector, where there's, again, a perception that there's an over-reliance on bringing in foreign workers. They're looking at removing the automatic right of spouses and partners to work without restriction in the UK. There'll probably be higher minimum salaries and possibly a restriction in the type of role that will qualify for visas. So watch this space when the report is released as to how that's going to play out, because it could have a big impact on your recruitment need. The second area of focus I think we're going to see is an increased emphasis on enforcement and prevention of illegal working. So we're seeing anecdotally from clients a report for those employers that have Tier 2 sponsorship license. They're seeing more frequent visits or audits from the Home Office, the government department that manages immigration, and also tougher penalties for breaches of the compliance duties. So that might be around document retention, it may be around reporting duties, but it makes it more important than ever that employers are on top of the various compliance and HR responsibilities they have as sponsors. There's also more of an emphasis on enforcement across the board. So even for employers that don't have Tier 2 sponsor licenses, there's a particular drive to try and reduce illegal working. There's going to be a new offence for employers to employ persons that it has reasonable cause to believe are illegal workers, which brings in a more sort of subjective element to whether or not employers should have known that somebody was an illegal worker. It means that employers can't turn a blind eye to the checks that they have to do. Particular emphasis in the construction sector, care homes, hospitality and hotels, where there's a high turnover of staff, where the checks aren't always done as well as they should be. There's also going to be a toughening up of the criminal offence for employers. So for management that are permitting illegal working, at the moment it's a maximum 2-year prison sentence. That's going up to 5 years, and the penalty was increased against employers for illegal working from £10,000 to £20,000 per illegal worker in the last year or two. So it's a drive to try and to cut illegal working by looking at everything that employers are doing. The final point, just on the headlines for immigration, is the referendum that the UK will be having on whether to leave the European Union, scheduled to happen at any time from now until the end of 2017, but it's thought to probably be later this year. The Prime Minister is negotiating with other EU countries to try and reformulate the model that the UK has with the European Union. The one thing that can't be changed is the principle of free movement of workers that all European Union states sign up to as a fundamental principle, which means that EU citizens can work in any other EU state without restriction. Now, if there were to be an exit, the reality is the consequences are likely to be several years down the track. There would need to be a period of intense negotiation between the different countries in the UK as to how that would play out in relation to lots of different things, but particularly in relation to immigration. It may well be that even outside of the EU, continuing free movement of workers is a mandatory requirement in order to keep the free trade agreements which everyone would want us to sign up to. So I think it's nothing to worry about, but it's going to be on the horizon, and it's ultimately several years down the track. It may make it more difficult to get the talent you want if there were more restrictions on EU citizens coming into your business. So what to take away? Look out for the report that's going to be published. We'll be sending out alerts when it is, setting out what the recommendations will be. That report will not be a change in the law. The government then have to implement it, but they almost always do implement those recommendations, and we expect them to come into force on the 6th of April, which is the normal date for immigration changes. If you're in a business and you're thinking about making an intra-company transfer from your North American head office, then you might want to consider making that transfer now ahead of those changes coming in on the 6th of April, in case those changes do detrimentally affect how you would do that. So think about bringing that forward on your timeline. On the enforcement side, always worth doing an immigration health check, particularly if you have a Tier 2 sponsor license, to see how you're doing against the various compliance duties of document retention. And also, give yourself as much lead-in time as possible. If you're planning to arrange a visa, the more time you can give to arranging it, especially if you've got to advertise and go through the various other hoops that some employers have to go through, give yourself enough time to do that. Thank you very much. I'm going to pass on now to Sian Skelton, who's an expert and partner in UK consumer law, to give you the latest developments.
Thank you, Charlie. Yes, my name's Sian Skelton. Good afternoon. And I'm a partner in our commercial tech team. And one of the topics that we thought might be of interest to you this afternoon would be to talk about consumer law. There's been a lot of changes in consumer laws over the last couple of years, and there are likely to be further changes later this year and possibly into the next. And it's a topic and an area that is growing in terms of importance and in terms of consumer rights, which obviously has an effect on businesses. But before we can look to what might happen in the future, we thought it would be helpful to consider what has happened over the last couple of years. Because actually what we're finding is that B2C businesses are still getting to grips with the changes that have happened in the legislation. So predominantly there have been two major pieces of legislation adopted in the UK over the last 2 years. The first is the Consumer Contract Regulations, which were adopted and came into force in 2014, and the second is the Consumer Rights Act, which came into force at the end of last year. The Consumer Contract Regulations were adopted by all European countries in a harmonised approach. So the sales of consumer goods under these regulations, and I'll go on to explain a bit more about them in a moment, will be the same across Europe, and all European countries have had to adopt them. The Consumer Rights Act itself is a UK-only piece of legislation. And predominantly it just consolidates and updates the existing consumer legislation, which was in a hodgepodge of different consumer acts and statutes and directives. However, what it has done for the first time is it introduced a category known as digital content, which gives consumers, for the very first time under UK consumer law, specific rights in respect of digital content when it becomes defective or it doesn't work. So if we turn first to the Consumer Contract Regulations, the key considerations that B2C businesses now need to be considering, and this applies to all contracts, so whether you're selling online or in the shop, is that certain pre-contractual information needs to be provided by the trader. And these go to things like if the consumer has a right to cancel or to claim a refund, then that information must be made available to the consumer up front before they purchase. Information about the goods and services. So if you're in a shop, that's all quite obvious because you can see, touch and feel the item. But if you're buying online, you need to be able to provide a description of those items so that the consumer understands what they're buying, what the good is, what the services is. In addition, if there's a specific provision around payment terms, again, obviously very obvious if you're just picking something up off the shelf, but if you're online and you have a subscription and billing period, that you'll need to be spelling that out to the consumer online before they make that purchase. The Consumer Rights Act also changed provisions in respect of delivery, so that any goods that will be delivered must be delivered without undue delay, and any events within 30 days, unless the consumer has agreed in advance. Provisions around risk, so that the risk of the goods only transfers to the consumer at the point when the goods are delivered to the consumer. And most interesting helpline charges. So, and I think this is a topic that a lot of businesses haven't fully implemented yet. So, where you're providing a helpline, a support line in respect of any of the goods and services after the sale has completed. So, it could be a query line, it could be a phone up to implement and get your product started. That should be provided at a free phone number or a local rate number as opposed to a premium number. And often what businesses have done to date have obviously been providing it under a premium rate number. Specifically, the Consumer Contract Regulations have had a quite dramatic impact on the online sales and other distance sales. So, and by other distance sales, I mean sales by way of telephone or on the doorstep or away from your usual retail premises. They allow the consumer a calling off period, which is a minimum of 14 days, although if you get your contractual terms wrong and your provisions throughout your contract incorrect, then it can be possibly extended for up to a 12-month period. So during this 14-day period, the consumer can receive the goods and then change their mind. for no reason, they can just change their mind and give you notice and then return the goods. That has to be baked into your terms and conditions as part of the sale process, but also, it's something to ensure that your returns policies and returns processes are up to date with this new period. With respect to digital content, this is also specifically regulated under these regulations, and there's a specific niche requirement for consumers that they must explicitly consent to receiving the digital content prior to the digital content being downloaded or made available to the consumer. If they fail to do so, if they fail to give that consent, or you fail to ask for that consent, the consumer has theoretically the right to turn around and say that they no longer want it after they've had use of it for up to a 14-day period after that. So a lot of the sales and process, especially online where you're signing people up, needs to be explicit around this point. And the final point I just wanted to flag on these regulations was that for sales made online, it must be explicit and very clear to the consumer that they are going to be paying for the goods or services, and that the button that they press at the point where they're saying, I want to proceed, must be a pay now button, or pay with an obligation, proceed with an obligation to pay, or words to those effects. Simply having order now, confirm, is not sufficient, and actually can mean that the contract isn't binding, and again the consumer can claim a full refund for those for that failure. Jeffery, who is also a partner in my team, is now going to go on to talk about Consumer Rights Act and future changes.
Thanks, Sean. So the Consumer Rights Act, it's got less of a high profile than the consumer contract regulations changes, but it is something that people who are selling goods, services or digital content to consumers in the UK need to bear in mind. What it does is it consolidates and modernises about 50 different pieces of UK consumer legislation into a single act. It modernises terminology, it clarifies some of the remedies if products sold to consumers are defective or not in accordance with the contract. So a lot of it is actually quite helpful. It is a purely UK piece of legislation. It came in October of last year, and many UK-based B2C retailers are still wrestling with exactly what it means for their businesses. Key changes that it brought around was first a new category of digital content, as Sian mentioned. Before this piece of law, we didn't know if a film streamed or downloaded or music made available over Deezer or Spotify, ebooks or apps, whether they were goods, and therefore a certain set of implied terms around quality, merchantability, if you like, in US terms, and so on applied, or whether they were services, in which case a very light implied term around reasonable care and skill applied. And that allowed people really to fudge it with consumers and decide exactly what kind of remedies they would decide to make available, as much as a kind of consumer relations issue as a legal one. Now, though, we know full well that streamed or downloaded digital content has its own specific set of applying terms, which includes terms around compatibility with hardware platforms and durability, which are actually quite challenging, I think, for those consumer retailers to work out how they should get compliant with it. So that's a key change. The other main changes I would draw out, and it's a chunky bit of legislation, but the main changes, I think the other one is, when working out whether anything sold to a UK consumer is in conformance with the contract, the law takes into account any public statement made about that product. So, of course, advertising and promotional materials are already regulated. We have an industry code. We have a bunch of EU regulations that, you can't lie to people about the nature of a product. But now we also know that anything you say, however fluffy it may be, whether it's in any kind of advertising, can be taken into account in working out whether that product is defective or not. So it just really focuses that materials clearance process from a UK perspective. The other change I should mention, and this is massively frustrating for people doing business in the UK in the B2C space, is that change, the Consumer Rights Act, is UK only. Meanwhile, in Brussels, the EU authorities have been working hard on a broad project called the Digital Single Market, as part of which we now have, as of last month, a draft directive which covers almost exactly the same ground as the Consumer Rights Act, but at an EU-wide level. And that directive will take shape. It's not yet in force. We don't yet have a time which it will actually hit the ground, and businesses will need to comply. But over the course of this year, we're expecting to see that in final form. So, of course, a challenge for a North American B2C retailer, whether in-store or selling online, in the UK and other European countries, is whether you take the trouble to get compliant with the UK legislation, knowing that you'll then need to make some changes to comply with the EU directive, or if you wait and do nothing, or if you get UK compliant with half an eye on where we expect the EU requirements to go. So there's a lot of judgment calls, which I think will be mainly driven by practical risk questions, like where are most of your European sales, where do you have boots on the ground within the European Union, and so on. So in terms of next steps on consumer contracts, I think for people with significant UK sales, it's about reviewing all your customer-facing documents, advertising materials, terms of sales service, returns policies, making sure that the playbook, if you like, that your support teams have takes into account all of these new rules, and generally make sure that whole consumer journey is compliant with these new sets of requirements. And now I'll turn over to James, who will talk to us about Dutch trade.
Thanks very much, Chris. So yeah, we just wanted to give you also a very brief overview and flavour of what's happening throughout the Netherlands and Germany in relation to employment and some data protection law as well. So what does 2016 have in store for the Netherlands? Well, the key areas to look out for will be changes to employees' flexibility in terms of where they'll be able to work and how many hours they're actually able to work. Employee independent contractor changes, which is a common theme, I think that will probably resonate with you. Increased data protection obligations, and also increased flexibility for employers in respect of employees working beyond the state pension age. So if we go to the Dutch Flexible Working Act, first of all, as of the 1st of January of this year, employees will now have more flexibility in respect of their working hours and working from home. So employees can not only ask for changes to the number of hours they work, but also changes to the times they're required to work and the place of work. An employer will actually now have to agree with a request to change the number of working hours unless there are substantial business reasons for not doing so. Previous case law has showed that business interests are rarely considered to be weighty enough, so it does look as though there will be increased flexibility for employees in this area. For a request to change the place of work, an employer has to take the employee's application into consideration and has to discuss it with the employee if it doesn't agree at all. Unlike in the case of a request for changes to the number of hours or to the times the employee works, this act does not actually provide that, and the employer needs substantial business reasons to turn down an application to change the place of work. One significant change within the Act is that employees can now request any of the above changes after just 26 weeks of service, whereas before they needed to have 1 year of continuous employment. I think one thing to note here is that the overriding employer's duty of care will become a lot more difficult to monitor, in that it will also extend to those employees that will be working from home, and so they'll have to have their workplace stations in the home environment monitored as well, which will require risk assessments to be carried out in the usual way that you might also expect in UK and other jurisdictions. So some interesting changes there to take note of in the Flexible Working Act. As I mentioned, there's often a fine line between what constitutes a payroll employee and an independent contractor, and this is something that's going to see a change in the Netherlands as well. So for some time, the position in the Netherlands has been for employees to obtain a declaration in advance as to whether their working relationship actually constitutes that of a payroll employee or an independent contractor. From April 2016, however, this form of declaration is going to be modified, and it's going to be replaced by a form of model agreements, which will need to be reviewed by a local tax and customs administration to give an advanced indication of tax liability. So, in essence, there's still going to be a method to get advanced clearance to determine employment rights and tax liabilities in respect of a given relationship, but it will just be a different method for obtaining that clearance. One important proposed change in relation to data protection is that now private and public organisations processing personal data now obliged to report to the Data Protection Authority any security breaches which result in the theft, loss or misuse of personal data. Significant is that penalties could run up to €820,000, or 10% of annual turnover. A change in the State Pension Age Act is also coming into force. In essence, there will be an introduction of more employer-friendly rules on working beyond the state pension age. And a few examples here will be that there will be an ability to hire employees on shorter notice periods if they want to work beyond the state pension age. You can look to hire employees on temporary employment contracts if they're looking to work beyond the state pension age, and the continued payment of wages during periods of illness will now be for 13 weeks instead of 2 years, so that represents a significant reduction. So that's a general idea of what's going on in the Netherlands. Let's now also have a quick look at Germany before we wrap up today's webinar. So again, in Germany, the primary focus is going to be on potential changes to the definition of employee and contractors. There's going to be some changes to look out for in agency worker law and also national minimum wage, which might have an impact on internships and things like that. So the first one to look at is planned changes in relation to the definition of employees in contrast to freelancers. So similar to the Netherlands, there are some changes here in relation to the classification of employees and contractors. Obviously, a misclassification can result in unwanted employment rights and tax liabilities. So at the moment, the position is that the government is holding discussions over a new restrictive definition of employee, which will essentially make it a lot more difficult to engage so-called genuine contractors. There's nothing that's gone through yet, but again, it's something to look out for. I think one of the important changes to look out for and represents a deviation from the current position is in relation to agency workers law. So currently, German law gives no clear upper limit on the duration of a temporary agency work assignment. And this is, of course, something which the German ministry has been looking into. So one of the proposed changes is that a temporary agency worker could not work for the same end-user company for more than 18 consecutive months without that then giving rise to a permanent employment relationship between that agency worker and the user company. Additionally, the draft law also looks to alter the rules on equal pay of temporary agency workers. So statute currently provides that such workers must be paid the same as equivalent regular employees of the user company, although it is possible for collective agreements to allow temporary agency workers to receive lower pay than their regular employee counterparts. Under the draft law, this exception would only apply to the first 9 months in the job. After this point in time, a temporary worker would then be entitled to equal pay. So again, we'll see when those changes come in, but it's anticipated it will be towards the end of this year. So I think the final thing to mention in Germany is changes to national minimum wage, and the backdrop to this is that there's been a long-running battle to try and increase the national minimum wage, and it primarily will have context within the internship arena. So at the moment, the statutory minimum wage in Germany is €8.50 per hour, and this is looking to be increased to €10. So when that does take effect, I'll have to make sure that all internships and interns are paid in accordance with the new statutory minimum wage. That gives us a brief overview of what's going on in Netherlands and Germany, and I'm now going to hand back over to Paul Callaghan, who will provide a roundup.
So thanks for that, James, and thanks to the whole team. I hope you found that useful. We have slightly overrun, so if you do have any questions, do email them to us. The slides will be sent out to everybody who has registered. And if you want an in-person visit, that may be possible too. Sean and I are going to be in Houston, LA, San Francisco, and Denver over the next couple of weeks, and Jeffery is also going to be on the East Coast in Boston and New York and Washington, D.C. We as a team, we regularly visit our clients and contacts across the whole of North America, so do feel free to get in touch and we'd be delighted to come and see you. Thank you very much for joining our webinar.